Hi, my name's Sarah Beresford from rocketlawyer.co.uk. We provide people with affordable legal help. Today we're here to talk about employment law, and we've asked businesses to tell us their top employment law questions.
Thanks, Sarah. Hello, I'm Olivia Sinfield and I'm a solicitor at PJH Law. We are a niche firm specialising purely in employment law. And we act in very close conjunction with Rocket Lawyer to provide businesses with employment law support and guidance. Now, I'm here today to endeavour to answer your top 5 employment law questions.
So Olivia, I'm setting up a new business and recruiting staff. What are the first steps I need to take?
Okay, when setting up a new business and recruiting employees for the very first time, there are a number of steps you need to take before their first day of employment. First of all, you need to purchase employer's liability insurance, and that needs to be displayed in the workplace somewhere where employees can see it. You also need to register with HMRC, and this can be done at any time, but ideally and at the very latest 4 weeks before you run your first payroll. On the subject of pay, you also need to consider what you're going to do about PAYE. Is that something you're going to self-administer, or are you going to outsource it to an external provider, as is becoming common practice? Now, it's absolutely crucial that you give thought to what are the terms and conditions you're going to offer to your staff. At the end of the day, this is going to be key to recruiting and retaining the best people. Ideally before the start of employment, but at the very latest within 2 months of the day they start work for you, you need to provide them with a statement of employment particulars. And there are certain things that must be set out in that statement. For example, of course, the names and addresses of parties, their place of work, the date they start working for you, the date of commencement of employment, their salary, their hours of work, and their job title. Now, at the same time as putting in place your contractual documentation, you also need to give some thought to policies and procedures. If you're recruiting more than 5 employees, then you must have a health and safety policy. However, there are other policies and procedures that we would recommend you have in place from day one, such as a disciplinary and grievance procedure and an equal opportunities policy and procedure. It's imperative, of course, as a new employer that you remain on the right side of the law, so you need to make sure that you are checking your employee's right to work in the UK, doing the necessary passport and visa checks and maintaining a central record of that documentation. Finally, depending on the industry you're in, you may have to undertake DBS checks, DBS replacing the old CRB checks. And again, that's something that needs to be done before the first day of employment. Once you've all done all that, you're essentially ready to go.
One of my employees is a poor performer. Am I able to have a conversation with them about leaving the business?
Okay, well, the starting point for any business when faced with a poor performance issue is to first of all consider implementing a capability process, whereby it's a 2-way process. You work with the employee to try and improve performance. That said, since the 29th of July of this year, there has been another option for businesses, and that is to engage in what's called pre-termination negotiations. Now, what these are essentially discussions between a business and an employee, in your case, your poor performer, about the possibility of leaving the business on agreed terms with an agreed package, rather than proceeding down, in your case, a capability road, or if the issue is a misconduct issue, down the disciplinary road. And what this change in law does is confirm that evidence of those discussions, those negotiations, will not be admissible in any unfair dismissal claim. This sounds fairly similar to the without prejudice rule, which continues to apply, but it's different in one respect. The protection is there in respect of this new right, even if there isn't an existing dispute. It's not without its limitations, however, and the key limitation is that the protection only applies to unfair dismissal claims. So if, for example, somebody is bringing any other type of claim, breach of contract or discrimination claim, evidence of those discussions will be admissible. So say, for example, if you're wanting to talk to an employee coming up to retirement about leaving the business, or talk to somebody due to return from maternity leave about possibly not returning to the business, and you subsequently face either an age discrimination claim or a sex discrimination claim, then evidence of those discussions would be admissible.
Are there any practical points I should bear in mind when having these conversations?
Yes, the proposals must be put in writing, first of all, in order for them to be legally binding. And you have to clarify the reasons for the proposals in writing, as well as the proposed amount of the payment and timing of the payment. Now, an employee has the right to consider those proposals over a period of 10 days, or a shorter period of time if that can be agreed with the employee. You should also give employees the opportunity to discuss the proposals face to face, and ACAS recommend that they also are given the right to be accompanied. So what you shouldn't be doing is setting everything out in writing or just corresponding by email. Now, the crucial point for employers is they must not engage in improper behaviour. If they do, that will make the discussions, the negotiations admissible in a later unfair dismissal claim. Now, unhelpfully, the ACAS code doesn't actually clarify what is improper behaviour. It says it's a matter for the discretion of each individual employment tribunal. But what is clear is that improper behaviour covers, for example, harassment, bullying, intimidation, or putting undue pressure on the party to agree. And that might include, for example, not giving them the 10 days for consideration.
What are 0 hours contracts and why are they so controversial?
Well, 0 hours contracts are contracts which do not guarantee any hours and any work, and therefore do not guarantee any pay. The reason why they're so controversial, and this has been bordering recently to the point of hysteria, is because the balance of power is seen as being so heavily weighted in favour of the employer. You know, to a business, these contracts afford a high degree of flexibility. Businesses have the opportunity to take on staff and give them work as and when required and just pay them for that work which they do. So it's a useful tool for a business because they can be used to satisfy short-term and ad hoc increases in the need for staff labour during peak or during busy periods. Then on the other side of the coin, you have the impact on the employee, and that's a completely different story. Because for an employee who works under one of these contracts, they have no guarantee of hours of work and no guarantee of pay in any particular day, particular week or month. And that can have dramatic knock-on effects on, for example, putting in place practical arrangements for childcare. They may struggle to demonstrate that they've got sufficient security to satisfy mortgage lenders. And at their very, very harshest, what these contracts do is they tie an individual to a specific organisation so that in the periods of downtime, when they're not being called upon, they're not free to go and work elsewhere. But equally, nor are they free to claim benefits. So it has a knock-on effect on their ability to claim job seekers allowance and child tax credit. Historically, for these reasons, these sort of contracts have really only been favoured by very specific groups, by, say, students who combine work with some study, and older workers who may top up pensions with some part-time irregular work. You know, bottom line is voters vote with their feet, and the fact that when the economy is healthier, people tend to walk away from these sort of contracts really does say it all about how they are genuinely perceived by employees. Now, you referred to controversy, and there has without doubt recently been a huge degree of controversy on this issue. We've seen workers at Hovis's bakery in Wigan, more than 200 workers go on strike. So we question whether, is this the beginning of a move back to strike action becoming more commonplace? We've seen intense debate in the House of Commons, and Ed Miliband has put forward plans to actually outlaw completely these type of contracts. And even Buckingham Palace has got in the act, where it's emerged that 0 hours contracts have been used for workers there.
I need to use 0 hour contracts for peak periods. Are there any tips?
Yes, the key point really is making sure you get the contract right, and this is well drafted and reflects the arrangements you have in place with your workers. If you get this right, then it is possible to avoid the workers having employment status and building up continuity of service. And this is important, as if that's the case, then you won't be facing unfair dismissal claims at the point the relationship comes to an end. But once you've got your contract in place, you do need to make sure that your practical arrangements with your workers do not diverge from the terms of that contract. So when we're thinking about what are the appropriate terms of the contract, what we would expect to see, for example, is there being no obligation on the worker to accept work from the business. They're free to decline it. If they do decline it, there's no comeback on them for doing so. And also they're free to work elsewhere during periods of downtime. Internally, we would also recommend that you do maintain a distinction between your employees and your workers, including those on 0 hours contracts. So, for example, a common error we see is workers and those on 0 hours contracts being labelled in internal memos or emails as being employees. We need to avoid that. Also, we should consider whether we can distinguish between the two groups by making some benefits available only to employees, for example, car parking spaces, mobile phones, and not to those on 0 hours contracts. I think a key point that's arisen over the last couple of weeks is that as a business, you really need to be considering how best you're going to manage any reputational risk. There's been a huge consumer backlash against these practices, and we've seen big organisations such as McDonald's, Sports Direct feel the full force of this. So it is a real risk. We need to consider that up front because it might affect our decision as to whether we're going to engage in using 0 hours contracts or not. And if we do, we put in place an action plan of how we would manage that. You know, at the end of the day, this is very much in the public eye at the moment. The Coalition are reviewing the use of 0 hours contracts. They're under intense pressure from Labour at the moment. We're in a country where we've got a national minimum wage, and this may well be the start of a move towards national minimum hours.